if we think that reveling in poverty and having absolute equality where we all have absolutely nothing, then we should definitely do this. It's a wonderful idea. This will be the grand equalizer because we'll all have nothing. The state will take everyone's stuff. It'll destroy the economy. We'll have the kind of joblessness levels that you have in Zimbabwe of 90%. You'll have the Maduro diet like you have in Venezuela where people lose 25 kilos. You'll have 2.5 million people trying to escape the country. I mean, if we want that wonderful utopia that has been tried again and again, but not properly, we haven't really tried real socialism, then we should definitely do this.
Hello, my name is Donald Futsek INCer and welcome to WorldView. At WorldView we explore everyone's perspectives on all things that can broaden our worldview. Today we're talking with advocate Mark Oppenheimer. Mark is a South African advocate with a special interest in free speech, constitutional law, municipal law and commercial disputes. He also excuse me. He has published articles about property rights, freedom of expression and affirmative action. He has been called upon for legal commentary on both TV and radio. He also hosts a YouTube channel, Constitutional Landmarks, dealing with the court's landmark cases. You can find it in the description below. Mark, good afternoon and welcome to you.
Excellent, thanks for having me.
So Mark, can you tell us about South Africa's new Equality Act? I believe it's called the Papuda Act. What are they trying to achieve with this new act? Some say it's quite dangerous what they're trying to push through with this new act.
Okay, so for clarity's sake, Papuda's been around since the year 2000, so it's an old act. It's constitutionally mandated legislation. So there's a few acts that the Constitution required the creation of, and Papuda is one of them. So it's the Promotion of Equality and Protection Against Discrimination Act. What's new is that there's an amendment bill, which would change some of the impact of that legislation. So worth us sort of thinking about, well, what does the act do? Two big things. The one is regulating discrimination and the other one is regulating hate speech. So there's been a lot of ambiguity in our law for a long time about what counts as hate speech. I have appeared in a number of cases, and the most recent of which is the matter of Kwalani before the Constitutional Court, which finally settles this question as to what counts as hate speech. But why there's been a difficulty is that the Constitution gives you parameters for what could count as hate speech. So the idea is that in Section 16, we all have the right to freedom of expression. It's a very broad right. It includes scientific research, access to information, artistic creativity, not just the output of the art, but the process itself. So very broad. And then it has these three limitations. So it says the right does not extend to 1, propaganda for war, 2, the incitement of imminent violence, and 3, advocacy of hatred on one of 4 grounds, race, gender, ethnicity, and religion, and that constitutes an incitement to cause harm. Okay, so let's unpack that a little bit. You'll see that you're dealing with quite serious cases where free speech right isn't there. So think about the harms at the end of those different exceptions. First one being war, so a very serious thing. Next one, imminent violence, violence that is going to happen immediately because of the speech. And then you have incitement of harm, which means you're calling on people to perform a harm against one of those 4 protected groups. And the argument was to limit it to those 4 instead of a huge range, because those 4 have gone through persecution in South Africa's history and are more vulnerable. But Papuda seemed to be much broader than that. So Papuda, first of all, extended beyond the 4. It had 17 different grounds, including belief, conscience, HIV status, sexual orientation. And then it had this list which sort of said, well, it's hurtful, harmful, incitement to harm, propagate hatred. And it was unclear whether that list needs to be read as and, in other words, all things must be present, whether it was or. So there was a case called Hasselman versus Galeba, where someone called someone else a monkey. And the court said, this is not an incitement to harm. That's not harmful in of itself. It's only hurtful speech. But we want to hold this guy liable. So the only way to read this act is what they call disjunctively. In other words, you interpret it as or statements. So the claim was that hate speech is hurtful speech. And so that case then set a precedent for Penny Sparrow, who also referred to people as monkeys and was held liable for hate speech. I then ran a case on behalf of the Human Rights Commission against Valapi Kumalo. Valapi Kumalo had said, we need to do to white people what Hitler did to the Jews. They should be burnt alive, hacked to death, and their children turned into garden fertilizer. And we argued, look, this is clear hate speech, but it's important that we try and protect free speech. And so we said the court must interpret this legislation in a way that's conjunctive. So all of those things must be present. It must be hurtful, it must be harmful, it must incite harm, and it must propagate hatred. And the court found that. Ultimately, the Kwalani case settled the question and found that the term hurtful is vague. It's, it seems to be connected to like a temporary emotional state, chopped it out, but said the rest of it must be read together in some ways. So basically, you must have the propagation or promotion of hatred is the one thing that must be present. And then you also have to have incitement of harm or harm. Now, what's interesting about this is that the court has said, look, we're a court. We don't create law. But we can tell you when laws are unconstitutional, but we can't create a gap. So we're going to have to fill this with an interim test. And so they say, Parliament's got 2 years. We say you can use this interim test, but you've got some room to craft around that. We know, for example, you can't include hurtful speech, and you must have at least these two elements present. But something to bear in mind, PAPUDA is civil legislation. So the sanctions that you can have for breaching PAPUDA are, you can make it be forced to make an apology or pay damages award or a fine, but it's not criminal. So the other legislation that's been sitting in the sort of back seat for a while is the hate speech bill. And that legislation has an or in it. So it says speech should be either harmful or promote hatred, and it includes all these different grounds. And that bill has just popped up for comments again. I just finished my submission to Parliament on it. And it's on its face unconstitutional if you read Kwalani. So there'll be, I imagine, some challenge to that. Okay, so that gives you the broad background to PAPUDA.
But yeah,
you want to know what are the new scary bits?
Yeah, go ahead.
Okay, so one of the things that's quite scary about it, so I've told you it regulates hate speech. It also regulates discrimination. And the way that we generally hold people liable in South African law is that you have to have intent. Okay, so you have to have negligence. So if you think about what we call a delict, it's it's the intentional causing of harm to another person, okay, or it's the negligent causing of harm to someone. So, for example, you can imagine someone who's drunk driving and they run over someone's foot. They didn't intend to run over the foot, but if you weren't drunk, you would have paid attention to the road. Reasonable people don't drive drunk, so you're culpable. Okay. Now, the concern with these amendments is that it changes the definition of some of the basic terms to allow for these unintentional acts of discrimination. Now, I mentioned to you that there are ways in which one can be held liable under the Act, so forced apologies, payments of damages, and also have your license revoked. And the way discrimination is understood in the Act also impinges on speech. So it talks about discriminatory speech acts. And it says because they can be unintentional, but result in some kind of almost like disparate impact. It's very hard to know in advance if the thing that you're going to say is going to impact on one of these groups. So, for example, let's say you say something like, racists are disgusting, and we should do what we can in South Africa to ensure that we expunge racism. Mm. Seems like the kind of thing you should be allowed to say, right? But racism is a belief structure. Okay, in other words, you believe that some races are inferior to other races. Okay, so it's a protected ground. So now you've got a situation where the racist can say, well, you've said something that we believe discriminates against us because it impinges on our dignity, which is part of the new thing. You're saying that there's something disgusting about us. And, we want your speech censored, or we want you to, have your license revoked to run your newspaper. And because it uses the strict liability requirement, which is really an apartheid relic. So there's a famous case called Parkendorf, where in defamation cases, the press were held liable regardless of whether they had intent or negligence. The idea was, the speech is defamatory, you're liable. Doesn't matter what you intended to do. And, in the news dispensation, our Supreme Court of Appeal said, no. You've got to protect press freedom. the rest of our law respects this idea of culpability. And what you have with the Papuda Amendment Bill is a reintroduction of that. So one of those things that's worth being wary of. It'll also have quite significant impacts on religious people as well, who might want to be able to, freely espouse their views, many of which will be viewed as offensive to someone on the grounds of, who knows what. And it's quite hard in advance to know whether you're going to breach this law, and that's the difficulty.
But it's also probably a factor here of, this can lead to a lot of cases. I mean, if you make it so open to interpretation, this can lead to a lot of cases. So, I mean, obviously, this is terrible, but not every single event where it falls short or it falls within the parameters of this bill will be prosecuted.
Well, bear in mind, so you've got two kinds of ways in which matters can get before the court. The one is that you've got something like the Human Rights Commission initiating them on behalf of someone, or in its own name, or it's private parties. Now, one of the things that's astonishing in the bill is the idea that the state would pay for complainants' legal fees, but not for defendants. Now, ordinarily, if you think about how legal aid systems work, you pay for the criminal defendant because you've got the big bad state with all the resources, and it's prosecuting some guy who's an individual, and he's been accused of a crime that could, have severe consequences for his life. And we say, okay, well, if you can't afford it, the state will help you pay for your legal fees. Yeah, they go, no, we'll pay for the guy who's going to lay the complaint. Now, it's not just individuals. There's also we call vicarious liability. So where you're liable for things that your employees do. And it's not just do, it's also fail to do. So it's acts and omissions. So you can have a situation where someone sues the corporation because they say, well, your employee didn't smile at me, and I see that as a sexist affront, or your employee did smile at me and I saw that as a sexist affront, and I'm holding you liable, and the state's going to pay for my legal fees. And, maybe what will happen is that you don't want to be dragged through court and have your reputation ruined and face this big damages award, so you can just settle with me and pay me some cash, and then we can all go away. So you kind of deal with this kind of incentive to litigate. You're kind of creating a bounty system. Then you're also creating this paralysis where everyone says, we've got to be very careful about the kinds of things we do and don't do because we could get hauled before an equality court. Not exactly good for the purpose of the act, which is to have reconciliation, to have people sort of trusting each other.
Yeah, a rainbow nation.
Yeah.
But I mean, so is there literally no requirement that you have to provide some evidence before the state pays you to prosecute someone? Or is it literally just, oh, it might have offended me, so let's go? I mean, pay me for that.
I mean, you might have some regulation that comes out that asks for a certain threshold of the nature of a complaint before they start punting for your legal fees. But it gives the state the power to pay for the defendant's costs. You already have it to some extent because you can complain through the Human Rights Commission, and there are cases where you can run an agenda through that body. So there's that concern already.
What is your perception around the idea of hate speech in general? Do you think it's something that should just generally not be in the realm of state law? I mean, it should just not be prosecuted.
No, I think there are some cases, some exceptional cases, which amount to genuine acts of hate speech where you do want there to be a sanction. I think you must think about a range of sanctions. So let's say at the lower end we have apologies. Then you could have fines. You could have interdict, so you restrain the speech. And then you could have criminal sanctions where you jail someone. So I'll give you a good case. In 2008, South Africa had a series of xenophobic attacks. There was a guy called Ernesto Nemuvwe who was Mozambican, and he was burnt alive by an angry mob. So you can imagine someone on a loudhailer saying, this guy's not one of us, he needs to be killed, and the crowd, douse him in petrol and kill him. And I think you need to hold the crowd liable who've performed an act of murder, but I think you also have reason to hold the speaker liable as well, who's riling up that mob in that moment. And I think if you actually have a harm that occurs, as in that case, then you have good reason for criminal sanctions. There are going to be other cases where what you have is really a raising of temperatures. So, you have the EFF sort of saying things along the lines of kill the Boer, or we need to slit the throat of whiteness, and so it's quite hard to prove a kind of causal link between that, let's say, and and people actually being killed. But we do know that you have a rise in farm attacks, that there are people who are killed out of racial hatred. It's quite hard to pin it to a particular act of speech, but you might want to hold them liable for that, that you're targeting a particular ethnic group, a minority group, you're calling for them to be killed. I think there's reason to restrict that kind of speech or punish the speakers. But I think what we've done in practice isn't that. Those guys aren't being punished at all. The people who are being punished are basically nobodies from the middle of nowhere, like Penny Sparrow, retired estate agents in the northern Natal, and who sort of, she's now passed away, but the Kamala judgment makes it very clear that she was wrongly held liable because this low threshold was used. So there are genuine concerns about things like hate speech because they can be used to settle agendas, they can be used for political purposes, and they can be used in ways that are disproportionate, the kinds of sanctions that are sought. So yeah, I think we should be wary of restrictions of speech, but I'm not an absolutist. I think there are some times when there's good reason to do it.
And I think that's one of the reasons why the EFF likes to say whiteness and not necessarily white people. It gives them that legal framework to dodge the prosecution against them.
Yes, I'd love to see someone try that for other groups. So if you said, I don't have a problem with black people, I just think we need to stop the scourge of blackness and have it expunged from our society. Or I'm not saying we should kill Jews, I'm just saying that we should stop Jewishness and slit its throat. That kind of thin veneer strikes me as incredibly dishonest.
Yeah, it's a dangerous slippery slope. But if we can pivot to another important or so-called important issue in South Africa, and that's expropriation without compensation. Now, it seems like the ANC and the EFF are not going to get along, and they're not going to be able to change the constitution. Does that mean now that bill to change the constitution is dead, and the only one is the one they want to pass through parliament?
Yeah, so to give a bit of a preamble on that, we've had this long call to change our constitution to amend Section 25 with the 18th Constitutional Amendment Bill. And then we've had this parallel process, which is to have the expropriation bill, which would be the legislation which operates. Now, from my reading of that expropriation bill, it is currently unconstitutional. It gives the state more power than it has under the Constitution. It would not pass constitutional muster, and the only way to have it passed would be through amending the Constitution. Now, as you mentioned, on the substance, what's being called for really is allowing the state to expropriate land and things that are built on top of that land. So your house, your business, your crops, not things like your car, not things like your shares. Those things aren't attached to land, but quite a lot of private property, and take it away from you and pay you nothing. So, by the way, there's an interesting game that gets played. So you'll see people saying, there's nothing unusual about this. All countries allow for expropriation. And it's true, all countries do allow for expropriation, but they pay you. So when the state says, look, we need to build this dam or this road or the Gautrain project or whatever it is, and we need to do it through your private land, they go, if you're not willing to sell it to us, we're going to forcibly take it from you, but we're going to pay you what it's worth, and it's going to be the market value. So our constitution currently says you pay market value, but you can adjust up or down based on some other factors as well. So the international law rule is, very clearly in favor of paying adequate compensation. And so, in my submissions to Parliament, I've made it very clear that if we pass this, we would be in breach of our international obligations. We currently sign up with a thing called AGOA, which gives us preferential access to the American markets. One of those requirements would be things like protecting property rights. So you're going to imperil a whole bunch of deals that are being done on that basis. Look, if we like the idea of trying out what the Venezuelans have tried out or what the Zimbabweans have tried out, if we think that reveling in poverty and having absolute equality where we all have absolutely nothing, then we should definitely do this. It's a wonderful idea. It'll be the grand equalizer because we'll all have nothing. The state will take everyone's stuff. It'll destroy the economy. We'll have the kind of joblessness levels that you have in Zimbabwe of 90%. You'll have the Maduro diet like you have in Venezuela where people lose 25 kilos. You'll have 2.5 million people trying to escape the country. If we want that wonderful utopia that has been tried again and again, but not properly, we haven't really tried real socialism, then we should definitely do this. But thank God that the ANC and the EFF cannot agree on this legislation, because the EFF say it's not radical enough for us. We don't feel like we're going to ruin the country enough for us. And you have someone like Ronald Lamola, Minister of Finance, saying, hey guys, this notion of custodianship, it's anti-black. This idea that we could annihilate the economy and turn ourselves, and he says, into Venezuela or Zimbabwe is a terrible idea. We shouldn't be doing this. So
Wow.
there's some sensible people in the room who kind of realize this is not a gambit you want to be playing with. And so I hope that it collapses, but you need to remain vigilant. It has not collapsed yet. The ANC and the EFF have been very virulent on this front, fighting tooth and nail to have this done. And thank goodness there is a coalition of the righteous who have made it very clear that you shall not pass. And so those organizations like AfriForum, Institute for Race Relations, Sakulika, the Free Market Foundation, have all said, we actually care about South Africans and we care about prosperity and we don't think that poverty is a good thing. So we're going to fight you hard. And we will make sure that every single step of the way, you will experience pain. And that's the one way to do it.
But in the meantime, it's just led to a massive disinvestment, only to not go through with the idea. So it's been an utter waste of time. It's literally the ANC, never fails to set the bar lower. But
they keep trying. I mean, it's amazing what they've done. I mean, my favorites, if you want a little diversion of how incompetent the ANC is, and thank goodness for this, because if you had socialists who were good at their jobs, we'd be stuffed. So thank goodness the ANC are totally inept. But one of the things that they're inept in doing is, getting their candidates ready for an election. It's now just come out in a constitutional court judgment that in 13 municipalities where the ANC govern with a big majority, they didn't get candidates together because of ANC infighting, because they didn't pay their staff for the last 3 months, because they took their POAE money they were supposed to hand off to SARS and they kept it, $80 million. And their staff were like, we need to eat. We're going to go on a go slow. We're not going to register your candidates. And so they would have auto lost in those places. They didn't run a single candidate on PR lists in the Western Cape, not one. So if you are so utterly incompetent that you can't even run your own organization, I mean, the idea that you should be running a municipality is laughable. So yes, I mean, thank goodness that they're inept.
Do you know why the DA has lost that court case? The constitutional court case that just ruled that the IEC should reopen the registration for councillors.
Yes, I took part in that case. I acted for the Institute for Race Relations. So I'll tell you what occurred. So first of all, it's a two-step case. You have the IEC saying, look, it's COVID. It's not free and fair for us to run an election. We've known about this thing for a year and a half, but we haven't been able to get our ducks in a row, and we can't do it. So we want a postponement. And the court says, no, you can't have a postponement. And one of the things that happens in that case is the EFF say, look, if you're not going to grant a postponement, at least allow us more time to put our candidate nominations forward. And the IEC specifically opposed that relief, and they say that is not possible. If we are required to run this election, we have a very narrow deadline. There's a whole bunch of procedures. An election is not one day, it is a process. We ordinarily get 90 days. We would be then restricted to 43 days to do it. We've got to verify that the candidates are correct. You've got to remove duplicate names. You've got to register the list. It is an impossibility for us to reopen the candidate lists. So no. And the Constitutional Court look at the EFF's release and they go, dismissed. Okay. But the court released judgment and they say, look, the IEC had said, we're going to reopen the candidate list. Suddenly it becomes possible. And they source their reason for doing this inside of the court's order, where the court said you can make amendments to the election timetable so far as it's reasonably necessary. And they say the IEC are wrong about that. It's reasonably necessary to register voters because you didn't have a voter registration weekend. And that is important. There's a whole bunch of individuals who are disenfranchised. You must have a voter registration weekend. But we definitely weren't talking about candidate reopenings. So the IEC are wrong on that front. Okay. The IEC had another argument to say, well, look, the election's being postponed and the act says if you have a postponement, then we can amend the election timetable. They go, it's not being postponed. You lost. What happened is that the date has changed because we declared the minister's proclamation unlawful. Because she just stole everyone's voting rights. All those people are unregistered. So it's a new date. It's fresh. So how does the IEC get to do this? It's in the first part, which the Act says it is in the IEC's determination if it is necessary to amend the timetable to make the election free and fair, then they can do so. And the IEC say, well, we think allowing these extra candidates to be in would be free and fair. Now, the court says something quite interesting. It says, look, the DA have alleged that the IEC are acting in a partisan manner. In other words, we know in prior cases where the IFP and the NFP had missed deadlines, didn't register candidates on time, didn't pay fees that you had to pay, that the IEC said, well, tough titties, that's how it goes, rules are rules, and we're not changing this deadline for anyone. But suddenly the ANC asked, after the EFF had asked, they said, oh, well, of course we can make a plan for you, no problem. So the court says, look, we don't know whether the IEC is biased. It's a possibility. We can't decide that on paper. So the DA are welcome to launch such a case after the election has occurred to determine whether that has happened. So it might be one of those things that comes out in the wash, we'll find out. But basically the court said, look, there's only so much a court can do. Ultimately, what the legislation does is grant the IEC this limited power. We've closed all the other doors, but this door still seems available. It is, of course, astounding that the body that said not possible now says we can do the Herculean task and we can make sure it happens.
But what options do the DA have after the election? What can they do against the IEC?
They can challenge the freeness and fairness of the election. And it might not be the election, bear in mind it's municipal, so it's 4,723 elections. And so they might want to be targeted about it. They might want to say, look, evidence has come to light. There's some whistleblower in the IEC says, look, we did this because we got ANC pressure and we knew we couldn't do it. And we knew that we sacrificed other things. So for example, as I say, one of the things the IEC was very concerned about is printing ballots on time. If you're changing the candidates, there's a possibility that you won't have certainty on your candidates in time. Or that you'll have people who aren't entitled to running on those lists. So, it's not like you can just keep adding stuff. There's a trade-off that's in play. So once those facts come to light, the DA can assess its options and see whether it wants to run challenges either to the whole election or to parts of the election.
Okay. Well, it seems like we're just going to see more and more court cases. But if we can pivot, I would love to hear your opinion on the issue of literalism versus contextualism. This is more and more a growing theme, especially in the United States. We have a battle between conservative, so-called conservative, and so-called liberal judges. Where do you find yourself on that spectrum? Do you believe in literalism or do you believe in contextualism?
Different ways in which they can play out. I mean, the one way that term is used in the States is they call it originalism, and they mean what did the drafters originally mean? And the other one is to say, well, it doesn't matter what the drafters thought. It matters what the text means. What's interesting about this is people make assumptions about your interpretive position and your political views. So the one line is to say, well, people who read the letter of the law very strictly are necessarily conservatives, and people who kind of read in other stuff are liberals. So there's a famous case in South Africa in the 50s. So there was a statute that said, if you are black or Indian or colored, you cannot own a business in this particular area. It's a whites only area. Okay. So a corporation gets set up, owned by an Indian family, and they operate in this whites only area. And so the apartheid government says, well, you've broken the law. And this question goes to the court, and the judges say, companies don't have a race. They said, this company is not Indian, it's not black, it's not white, it's a company. The fact that the owners happen to be Indian, well, that's neither here nor there. And so they took a very literal approach for a progressive reason. So the other example of it is on whether sexual discrimination on the grounds of sexual orientation is unlawful in America. So South Africa is quite progressive in that sense that we include sexual orientation as a listed ground in our constitution. The Americans didn't in their civil rights statute. So I think they have race and sex in there. And so the question was, is it okay to fire someone because you find out that they're gay? Okay. And so they're not explicitly protected in the civil rights statute, doesn't mention sexual orientation. And so you have, I think it's Gorsuch, who is a Trump appointee, and you have Kavanaugh, also a Trump appointee, and they have this interesting debate. And they both say it's immoral to fire someone on the grounds that they're gay. Okay. And Kavanaugh says the way to cure this is for the legislature to pass a law to amend the Civil Rights Act. So they've tried to do it a couple of times. They've gotten very close. So at the one point the Senate did it, and the other point Congress did it, but they couldn't do it at the same time. He says that's the most democratic way to do it. Add it in. Gorsuch says no, we don't need to do that. If we take a very literal interpretation of sex discrimination, he says, why are you firing this person? He says, they're a woman who has sex with women. Okay? And if they were a man who had sex with men, you wouldn't have fired them. So the real grounds for them being fired is their sex, not who they're attracted to. And so he says on a literal interpretation, this is a breach. So again, your interpretive stance doesn't
Interesting.
necessarily commit you to any particular values. My view is I get very worried. One of the things that you want in the legal system is legal certainty. I want to know in advance, is this thing okay? Is it free for me to do this? And if the law can be interpreted any which way, then you don't know. So I do have those concerns when we start to sort of take this purposive line, or we read in what we feel like, then I don't think you're doing law anymore. Then I think you're doing something else. And you might just want to say that, being honest, and say, look, the law has run out. We think that justice requires us to do something different, and that is what we're doing. But judges kind of need to pretend that that's not what they're doing, that they're abiding by the law and that they're using an interpretive tool. This thing was always there. But I do think that there is a danger in it. And I think you rather want to, cure the bad laws through a law reform process. There's going to be some room for judicial activism where you can say, look, there's reason to believe that we can interpret this law in this way, given the framework. But there's times when it starts to look ludicrous. And there have been a couple of decisions that have come out where we say, you've bent this so far beyond what that could possibly mean that it's untenable. We do have some sort of interpretive rules. There's not much of a debate in South Africa about it, but basically our view is, you must read the words through their ordinary meaning based on the context of the statute, as long as it wouldn't produce some kind of absurdity. So that's the idea.
Yeah, no, I couldn't agree more. And one thing I also, like you said, found very annoying is when people associate a court's or a judge's decision with political views. So if he found 4 Republicans, he's a Republican. But it could just be his interpretation of the law. It doesn't have to do anything with a political view. But in terms of something that can be openly interpreted either way, I recently spoke to Professor Koos Malan, and we both agreed that Section 10 of the Constitution, I believe it's Section 10, the right to human dignity, is a very open, ambiguous, and almost pointless right. Obviously, we all want a person to have dignity, but I mean, to guarantee it, it's like saying every person has the right to happiness. I mean, what is your opinion on that right?
Yeah, I mean, the Americans actually do have life, liberty, and the pursuit of happiness in their constitution. Dignity is a complicated word, and it's got an interesting history, and so you're going to have a lot of fighting over what dignity means. So, for example, in the Kulani case, both sides relied on dignity for the outcome that they wanted. So the one line say, well, dignity is about your well-being. It's about your emotional state. It's about people not saying bad things to you. It's about feeling good, about happiness, that sort of stuff. And the other line, which has a rich tradition in Immanuel Kant, is to say dignity is about autonomy. Dignity is about being able to make free choices. So when you hamstring someone's dignity by not making them be able to exercise free choices, that's a problem. And so free speech and dignity are necessarily tied. That if you infringe on someone's free speech rights, you're infringing on their dignity rights. So yeah, and our law is kind of all over the show on that front. You have these competing understandings of what counts as dignity. Also, you have this difference between positive and negative rights. So the one is to say, look, do I have an obligation to make you happy versus do I have an obligation to not make you unhappy? So the liberal view is I should have the freedom to swing my fist at the edge of your nose and no further, or that we should have mutually compatible freedoms. But I don't owe you anything. I don't have to give you stuff and make sure you have this fantastic life. It's very good if I do that. I'm doing a charitable thing, a virtuous thing, but I don't have an obligation. Our constitution obviously has these socioeconomic rights where the state does have these obligations. It must provide people with access to healthcare and housing, but that comes at a cost because the state doesn't have any money. You and I have money, and so the state is going to extract our money through taxation and give it to other people.
And so you said that in America they have the right to pursue happiness. I think that's the difference between a right to happiness. There's quite a difference there. But if we can pivot once more, my dad and I both study law, and it's quite a tense topic in our household. If I tell him that I believe it's called the Law Society, it's almost like a guild. By forcing people to have a degree, you make lawyers a sort of an elite cliché group, right? They become more expensive and not as easily accessible. Do you believe a law society is almost like a guild?
Yeah, it's an interesting thing. I mean, we actually did have kind of private guilds for a while, so you had the bar councils and the law societies and you had self-regulation. And I think, as you say, they acted very much like guilds where you try and protect your members, you create rules so that other people can't do that work, you protect it, you try and buff up the value of your members, you try and have lots of different requirements to make it hard to get into the guild. And some of that stuff is just self-serving. It's not rooted in reason. And some of it is saying like, look, when the public goes see a lawyer, they don't know what they're in for. So if you've got an ailment, you've got like a sore back, and you go, well, I don't know, this guy says he sorts out backs. I don't know how you do that. And you go there and he sort of like rubs some magical oil on you and does an incantation and charges you a bunch of money for it. He's ripped you off. But if he's like a licensed medical practitioner, you can sort of know, okay, well, this guy's gone through the paces. He understands how, which drugs work, which treatments work. Like I know that I'm in for some basic level of service. And I think law is the kind of thing that is very arcane. It's a lot of people think they know what the law is because you can read the Bill of Rights quite easily. It's an accessible book. Everyone really should have a pocket constitution, around. But as we pointed out, something simple like everybody has the right to human dignity, there's volumes of books written on what does that mean, and there's a legitimate debate about that. Often people say to me, they go, so you can go to court, you can be before one judge and you can lose, and you can go on appeal and you can lose before 3 judges and a full bench, and you can lose before 5 judges at the Supreme Court of Appeal, and then you can win at the Constitutional Court, and you could win by a slim majority. It could be 6-5. So most of the judges all the way were against you, but the final 6 took your view. And it's because law is complicated. As you mentioned, there's different ways you interpret things. There's a mass of different things. It's a complicated thing. So I do think there's some areas where you do want a certification, and it does cost a fair amount of money to go and train. Lawyers kind of don't earn very well for the early parts of their careers. While you're doing articles, you're getting paid a pittance, or when you do pupillage, you get paid nothing. Your startup expenses are expensive. So there's a cost to that. But as you say, there's a cost to the law society as well. It does make it hard for people to access justice. But the chances of them accessing genuine justice might be there because of the certification. But we now have the state playing this role. So you have the Legal Practice Council. And so the Legal Practice Council is a state-run council, and again has these various rules that regulate the profession, tell you what's professional conduct, what's not, channels the complaints. It's a new body. It'll be interesting to see how it plays out.
Okay. And yeah, that would be interesting to see. I didn't know that. But I mentioned Professor Chris Milan, and in that interview, he mentioned that the JDC, the Judicial, or I can't remember, the Services Commission, is compromised. It's compromised by the ANC. Can you give us some examples of that? Because he didn't mention the precise examples. How is the JDC compromised?
Yeah, so I suppose there are 2 ways we can think about it. The one is that it's structurally compromised. The way things run in the States is interesting. So we talked earlier about Trump appointing these 3 judges. And so when it comes to appointments at the highest court, and through lots of other courts, it's a presidential discretion. They have to go through a confirmation hearing process. I think you have to have 51 senators sort of agree. And so that, it's become quite partisan over there. But we don't have that process. So what you have is instead the worry was, instead of concentrating power on one figure like the president, that you would diffuse the power. And so you have, I think it's 23 people who are on the JSC. Some of them are in the legislature, so they're from political parties. Some of them are academics. Some of them are from various legal bodies like Advocates for Transformation or the General Counsel of the Bar. But what we found, and what's interesting, of course, I will say this, we're quite good at being transparent. So, if you want to watch the country fail, at least it's not happening only in closed rooms. You can watch some of it through live hearings. So, for example, a lot of the Constitutional Court cases that I've mentioned, the recent ones, are live streamed on YouTube. You can watch it live. You can see the argument. You can see the reasoning. You can pick it apart afterwards. And so the JSC is filmed. The most recent controversy has been in nominations to the Constitutional Court. So there were 2 vacancies. And there will be another 3 vacancies. Now, the court only houses 11 judges. So 5 coming up basically at the same time in October is quite a big deal. You could have a revolution in the court in terms of who's there. Now, what came out was that the process of the interviews struck the public as just so filled with vitriol and bias. So, for example, David Unterhalter, who's probably regarded as one of the the most impressive senior counsel this country's ever seen, who practiced in London, who was a judge at the World Trade Organization, and has been a judge at the Johannesburg High Court. Half of the questions that were put to him were about the small amount of time he spent at the Jewish Board of Deputies. So the Jewish Board of Deputies, basically like a charitable organization that's been around for, I think it's close to 100 years. He was specifically involved in helping out with the old age homes. So during COVID, you had a lot of people who were facing hard times. And so they asked him to lend his expertise, which he did for a period of about 7 months. And the vitriol directed him for this, to say, well, we think that the Jewish Board of Deputies is a Zionist organization and Israel is an apartheid state, and you should be ashamed of yourself, and how dare you, and this sort of stuff. Instead of saying, Judge, can you tell us about the work that you've done, in your many years of practice? We want to sort of test your judgments, test your rigor, instead of sort of purity testing people for their beliefs or the charitable projects they get involved in. Now, it was so obviously biased that CASAC brought a review application. So what happened was 5 people were selected, their names were put forward, and the president was to pick from those 2 names. And CASAC brought a review to say, we think this process is biased. It came out that Chief Justice Mogoeng, who presides over the JSC, had presented the JSC with a closed list of these 5 names, and that there was no record of internal deliberation. Possible deliberation happened, in other places, but basically there was a rubber stamping, and they said, look, your obligation as the JSC is to apply your mind. You can't just be presented with a list and say, looks good to me. You have to, say, well, this guy for these reasons, or this person not for these reasons. And so ultimately they conceded that there was a nullity and that the process was irregular, and they're having those things done again. I think the public are waking up to the concerns of the JSC. I think a lot of people have felt that the judiciary is the last bulwark against state capture, that we've got a largely useless parliament, a national executive that's sort of filled with people who are charged with various corrupt dealings, who belong to a party that is openly rotten, doesn't seem to be doing much reform at all. But the feeling is, but the judiciary can save us, and the judiciary has saved us on a number of occasions. So of course the judiciary are going to be under fire. There'll be moves to try and make sure that your guys are there. Ron Pauser testified to the fact that the ANC have an internal committee where they said we deliberately tried to get certain judges selected, that we gave those members of the JSC that are ANC members a mandate to go and pick certain people because it would be in our interests. These are our guys. I mean, the ANC have an open policy of cadre deployment. So it's not surprising that they'll be trying to do that, in the realm of the judiciary.
So many of the members on the commission are very left-wing.
Sure.
Okay, but is it a case of they are supporting the ANC, or are they left-wing? Which one do you believe is it?
Well, clearly there's guys who hate the ANC, like Julius Malema. It depends, what side of bed he wakes up on. Sometimes, Zuma must go to jail, and sometimes like we need to, hands off Ubaba. So who knows with that guy? But officially he doesn't, hold a torch for the ANC. But it's clearly very far left. If you sort of think about that political quadrant, I don't think left and right are very useful terms. You've got to have the up and down as well. And so people on the top end of it are totalitarians. People at the bottom end are libertarians or anarchists. And if you're on the left, you care about, equality, lots of redistribution. If you're top left, you care about doing that through the state. So you're like a Stalinist or a communist. If you're on the right, you care about free markets. So if you're at the bottom right, you're like, there should be no state whatsoever. People should just freely trade with each other. So I think we have a lot of people that are, very keen on redistribution and very keen on the state doing that, and those guys sit on the JSC.
Well, that's a shame. But we recently found out that our esteemed former president has been released on medical parole, and many South Africans are wondering how the hell did this happen again. So, how did this happen? Because if I understand correctly, if you're out, you're out. I mean, if you've managed to escape the prison, it's very hard to get back in.
Yes, your medical parole can be cancelled. There is a supervisory process. You're right to say that they wonder how did this happen, because we don't know. We know a few things. We know, for example, that Arthur Fraser, who was a mate of Zuma's beforehand, made the decision to release him, despite the fact that the medical parole board advised against it. We don't know what the medical reasons were. So this thing is governed by law. So it's Section 79 of the Correctional Services Act that sets out the basis for medical parole. And it used to be just terminal cases, but there are other lesser things besides terminal in which you can have a release. But they've got to be very severe. And there's a list of examples in the regulations of the kinds of things that would count. It's not a closed list, so it says it could be other things, but it's like stage 4 AIDS. It's very severe forms of cancer or like heart disease. It's not just like, the bed sheets here aren't really kind of agreeing with my delicate skin. So can I go home now? And Arthur Fraser said, well, I'm sure people want to know why I made the decision, and I'm sure Parliament's going to ask, and I'll tell them. And he hasn't told anyone. So two parties have brought litigation to have it set aside, the DA and the Helen Suzman Foundation, basically saying, look, whenever you exercise any public power, it must be done, rationally and with reason. And we don't think that happened. So show us what facts you had when you made the decision. And if they're not sufficient, well, then we've got to set that decision aside, and then Zuma must go back to jail. So on this front, you mentioned at the beginning of the show that I run this YouTube series and podcast called Constitutional Landmarks, and it's about big cases dealt with by the Constitutional Court. And so the inaugural episode is on Zuma, and I deal with two things. So the first is the contempt case. So there's original footage from the judgment, so read by Cesar Campepe, and then there's also what she says on the reconciliation application to say, well, we think the court's got it wrong, and so Darlene Porphyry came to court and said, can we have another chance? And the court said, not on your life. And so there's a nice recording of that explaining why. And then in the middle of it, I look back a little bit in time and I say, well, this isn't the first time that the Constitutional Court has held Zuma to account. There's the Nkandla case. And really at the time, this was massive deal. The idea that the public protector could produce a report which could require the president to pay back the money. Then Nkandla cost 250 million rands worth of taxpayer money. And that the Constitutional Court, those judges, many of whom were appointed themselves by Zuma, the Chief Justice in particular, reading out his judgment. And he says this striking line where the sword of justice must chop off the rotting head of impunity. So there's that footage from Mkhweng. And then I go and interview two advocates who were involved in that case. So the first was Wim Trengove, and the other one is Gilbert Marcus, two of the sort of, I'd say, leading lights of constitutional law, and have been involved in a massive amount of fascinating constitutional court cases. So the rest of the series then will deal with those sorts of things. We talk about the death penalty, we talk about gay marriage, we talk about the TRC. So yeah, if you're interested in constitutional law, you kind of get an eyewitness account with the show. So feel free to subscribe.
No, definitely, I'm going to watch it. I mean, I'd love to see your view on the advocate's view on every one of these cases that decide South Africa's fate. But I mean, Mark, advocate, thank you so much for your time. I don't want to waste or spend up any more of your valuable time, so I want to give you one last opportunity to add, plug, or say anything, or if there's one question you wanted to answer that I didn't ask, go ahead and do that now.
I think we've covered so much. It's been really fantastic. Thanks for having me on the show, and I look forward to doing it again.
Great. Well, thank you, Mark. And to our viewers, if you've made it this far, please consider liking this video, sharing it as widely as possible, and subscribing to our channel. My name is Donald, and this has been WorldView.